All right, let's talk about the kid issues in Texas. So obviously, if there's a divorce in Texas that has kids, Texas requires that the kid issues be addressed in the divorce. But obviously, you can have a legal proceeding regarding the children without having a divorce. So imagine people that were never married, or imagine people who are married but they've been long-term separated and they're not ready for a divorce yet for whatever reason. So you can actually do a child custody case without doing a divorce, but if it's part of a divorce, you have to do the custody also. Custody is an interesting word because you and I use that word, but the family code doesn't. In Texas, what we talk about is conservatorship of the children, and we talk about possession and access to the children. Child issues in Texas really revolve around the rights and duties that the parents have with the children, the possession schedule for the children, child support for the children, and the medical support, the insurance for the children. Those are the four main topics that we deal with in any case involving the kids. Can parents agree to a possession schedule? Sure they can. There are lots of folks out there who can agree that they will do some kind of 50-50 possession schedule with the kids. Lots of people will reach agreements on what they actually want to do as far as visitation with the kids. When it comes to the rights and duties, sometimes the rights and duties only make sense depending on the possession schedule. I wouldn't want to give the primary medical decisions, psychological, educational decisions to one parent if the other parent has the vast majority of the time with the kids. If you only have the time, 1 weekend a month with the kids, then you're not taking them down for an elective medical procedure. That doesn't make sense. So sometimes the rights and duties follow the possession because it just makes sense that way. You can have one parent with exclusive right to make some decisions. You can have both parents with independent rights to make decisions. Something that we're doing a lot more and we're seeing from a lot more attorneys in the area is rights after meaningful consultation with the other parent. So, which is not the same as asking permission, but just involving the other parent in those decisions. Texas presumes that one parent should be paying child support. The code is kind of set up to make one parent pay child support. We can reach agreements about child support. In some circumstances, we'll agree to no child support, and the judges don't like it. There are some ways we have to get around what the judges are going to want to do. Okay. But if it's left up to the judge, rest assured, somebody's paying child support. And when it comes to child support in Texas, Texas doesn't even consider both parents' income. It's just one parent's paying child support and you pay the full amount that's according to the guidelines. It sucks. The child support law in Texas is terrible. It's archaic. I definitely hope that the legislature will get on board and move into this century about that. But for now, it is what it is. And I just help my client as best I can, whichever way we can. And then when it comes to health insurance, the state presumes that the kids need to be covered with some kind of health insurance. If one of the spouses or one of the parents can get insurance through their work, then we're happy to do that. If neither parent has access to insurance, we have to put the kids on Medicaid or something. When it comes to custody in Texas, really you're looking at four different factors. You're looking at the access and possession, the rights and duties, child support, and the insurance issues for the kids. Best interest of the child. That is where lawyers make money. The family code says that when we're dealing with kids, the court must always consider the best interest of the child as a priority. Anything that we do, we want to show that this is what we believe is in the best interest of the child. Now, here's where the rub happens. Parent one has a plan for the kids that they think is in the children's best interest. Parent two has a different plan, but they believe it is in the child's best interest. And then, of course, the court has a plan that the court believes is in the child's best interest and is rarely either one of the parents. If you leave it up to the courts, I have a belief that a lot of the judges take some pleasure in making sure that both parents don't get everything they want. It is rare that we go to court fighting about best interests of the child, that the court allows one parent to walk away as an absolute victor and the other is an absolute loser. Okay. Usually what happens is the court will find something kind of in the middle that disappoints both parents. When you're talking about what's in the child's best interest, y'all, that gets really complicated, and this is where lawyers are good lawyers or mediocre lawyers, because sometimes you've got facts that are completely different. I've got one parent that's really focused on academics. I've got one parent who's really focused on the health and well-being of the children, wants the kids in counseling, and is forever taking the kids to the doctor. And the other parent doesn't go to the doctor's visits, but is super invested in their academics. Those two parents, they've got best interest arguments that they can make, but they're not even related. This is apples to oranges. And when we go to a hearing, the court's having to figure out which pieces of the apples and which pieces of the oranges we want. And then you start factoring in bad facts. You start factoring in substance abuse problems by the parents. You start factoring in a 9-year-old kid who's perfectly normal and a 15-year-old older sibling that's an absolute train wreck, is skipping school and stealing things and getting into trouble. What's best for those kids is not even same between the siblings. So best interest of the child is where lawyers make money in court, because we've got to fight those out based on the facts. And it gets really complicated. Even how you present it to the court can help determine whether you win or lose on that battle. Okay, so best interest of the child, big gray area. Yes, it's in the code, but the code doesn't define what is in the best interest, because there are so many factors that could come into play, and that's where lawyering comes in. Modifying a possession schedule in Texas is complex work. You just got to know on the front side, it ain't that freaking easy. Really, you've got 2 or 3 different distinct places where you can modify a possession schedule. You can modify a possession schedule during the pendency of a divorce. So imagine that you've started a divorce and we already have a possession schedule, and something happens during the divorce proceedings during that time frame where this possession schedule suddenly is not working. Maybe one of the parents moves in a new boyfriend or girlfriend who's a doper. Or maybe the kids start skipping out of school and there's no rules at that parent's house, and now the other parent wants to come in. So there are rules about the procedure for going in during a time where there are already temporary orders running. So you got to go back in and modify a temporary order. There's a procedure for that. Modifying a custody order in Texas requires a material and substantial change. The way the family code explains that, it just says a change has to be material and substantial. An interesting note is many courts seem to just run those together as if any change is material and substantial. My reading of the code indicates that the change should be both material. It's got to be a substantive change. It's not that the kid dyed their hair a different color, right? That's not material. That's not a big deal. It's also got to be substantial. So something that is enough of a change that it requires court intervention. The code presumes that small changes, the parents could just work that out. It should be both material and substantial. So when you want to modify a custody schedule, or you want to modify the child support, or you want to modify some kind of right or duty to the child, you've got to have a material and substantial change in the circumstance that warrants going back to court. The code intentionally leaves what is material and substantial kind of open-ended. And again, this is a place where lawyers make their money. I've had judges say that, I could say, Judge, there's not been a change here. Everything is exactly the same as it was 2 years ago when the parties agreed to the current order. And the judge said, well, the kid's growing, ain't he? He's eating more than he used to, which costs money. That's a substantial change. Just the kid growing up with no other changes was enough for that judge. But obviously, if we find out one of the parents has made some kind of legal mistake, one of the parents has picked up a DWI, material substantial change. What if one of the parents has moved in a new boyfriend or girlfriend and now there's family violence or drug use in the house? Material and substantial change. There's lots of things that could be a material and substantial change. If you have a question about it, this is where you need to consult a lawyer, right? You need to give us a call. Happy to talk to you. And we want to help you change the facts if the facts need to be changed. What happens if you want to move locations with your kid? You want to move out of the area. Y'all, this is a really tough one, okay? In Texas policy presumes that it's in the child's best interest to have a regular and ongoing relationship with both parents, provided that the parents are a good influence, right? It is common, it is normal, and it's presumed that the court will establish a geographic area that the kids are going to live in. Now, strategically, when we represent a parent, we always want the biggest geographic area we can get, because that allows the parent to move as far as they can to pursue new job opportunities in the future, to move from an apartment into a house and, get a little land for the dog and all that. So we like to get as big of a geographic area as we can. Usually what that means is Tarrant County and the contiguous counties. So that's a pretty big area here in the Dallas-Fort Worth area. If the other parent already has a big geographic area and we represent the other parent, we want it as small as we can, so that we make it as easy for our client as possible to have that regular and ongoing relationship with the child without having to drive 100 freaking miles. You can't have a 50-50 possession schedule if you live an hour apart, because neither one of you can get the kid to school every day. You can't have Thursday night overnight visits if you live on opposite sides of the Metroplex, because you can't get here easily during rush hour traffic to pick up the kid. So that doesn't work. We like to try to get that geographic area as small as we can. So this is a place where lawyering comes in. The real question here is, what happens if you have a geographic area established and then one parent wants to move out of it? Y'all, that's a tough nut to crack, because if the court allows one parent to move with the child out of the geographic area, it necessarily makes it more difficult for the child to have a relationship with the other parent. So if you have the primary residence for the child and you want to move out of the geographic area, it's going to be very fact specific, and you need a lawyer to help you with that. You're not going to go to court and say, hey, judge, I have an opportunity for a job in Colorado. Okay, that's not going to fly. You can move to Colorado, but the kid stays with the other parent. So understand that if it comes to leaving the geographic area, it could mean flipping custody if you want to go that bad. What facts could exist that would allow you to move if the other parent isn't taking their visits, if the other parent hasn't seen the kid in several months, if the other parent is incarcerated? There's lots of different things that could allow the court, but again, that's lawyering work. A person walking into the court on their own saying, hey, judge, I need to move to Nebraska, probably not going to get very far, okay, because it's going to be very fact specific, which means a lot of testimony and a lot of exhibits, and putting all that stuff together for the court in a way that wins is pretty complex, even for skilled lawyers, okay? So that is definitely not a place you want to go in by yourself. If there is already a geographic restriction and you want to move out of it, you for sure need a lawyer.